That's outside the plea bargain agreement.
It's in our plea bargain.
No, it's outside.
It is part of our plea bargain.
Just answer my questions.
Yes.
Okay, what was that? That's what I said. What was
1
your next
week.
contact after the 9th of June?
A week after that.
Except
We-
that he's not a good candidate for probation.
He's not?
No, he's not. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no
Please.
I don't know what you-
I just want to testify. I didn't.
Patrick
But
Washington.
I know sometimes you think I talked a little more than maybe is
No,
necessary.
no, I,
I just want to know, Your Honor,
oh,
for the record.
for the record. Victim impact panel and DWI intervention. Did you understand that to be your plea? Defense, is that the plea?
The plea includes an option of either 10 years jail, 10 days jail.
That's outside the plea bargain agreement.
It's in our plea bargain.
No, it's outside.
It is part of our plea bargain.
What I'm telling you, counsel, is this is your plea bargain agreement. This is outside the agreement.
Well, it is my understanding it's part of our plea bargain.
All right, I'm telling everybody, it's not a part of the plea bargain agreement. Note, this is what it reads. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and condition of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement. However, the state or both parties make the following non-binding recommendations. And what it says is 5 years community supervision, TAP evaluation, 120 hours of community service restitutions, 2-year driver's license suspension, 10 days house arrest in lieu of 10 days Bexar County jail. That's not a part of your plea bargain agreement. You all can present that to me and I can either follow it or not follow it, but that's not a part of the plea.
Is the 5 years probation part of our?
No, it is not. The court
So-
determines the length of a probation.
And if you reject that 5 years, then it's a rejection of the plea bargain agreement.
No, if I don't follow your length or your suggestion for the length of probation and I give you, let's say I were to give you 8 years on probation or 4 years on probation, that's not a part of your plea bargain agreement and I have not violated your plea bargain agreement because the court determines the length of probation, not attorneys.
Then Judge, I think we can't go forward with this because our understanding of what a plea bargain agreement differs.
All right, well, what I'm telling you all, according to the law, you cannot come before the court and tell the court, I want to be on probation for 5 years only. Y'all are not allowed to enter that agreement, period.
Now, Judge, you do not have to follow that agreement. That is correct.
That is not a part of your plea bargain agreement, counsel. The court decides the length of probation that somebody is on. The attorneys do not. The attorneys just make a suggestion. I'm going to read it again. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and conditions of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement.
Is probation
then-
part of the agreement?
Yes, they're recommending probation. Now, if, for example, if I were to say, okay, you guys have agreed that he's to have probation and I say I'm not giving you probation, then I will have violated your plea bargain agreement. But the length of time, the conditions, that's completely up to me. You all can't enter into a plea bargain agreement telling the court what your conditions will be.
That is not my understanding of the practice in this county.
Well, if people are practicing that different in this county, and I don't want to be mean to anybody, but if people are practicing that differently, then they are practicing the law incorrectly because the court decides the length of probation. Nobody else does. Defense attorneys don't decide the length of probation. The state doesn't decide the length of probation. The court does. Nobody else does.
Well, I guess my concern is moot at this point unless you do not follow our agreement.
Well, the question becomes, what do y'all think you have agreed to? Because if you think you've agreed to how long he's going to be on probation, that's not a part of your agreement. So if you all want to reread your contract, you're more than welcome to reread the contract. If you all want to go forward, you can go forward.
Well, Judge, I guess I need to review that comment
Sure.
and we'll come back to it.
All right. And State, if you want to show him.
Words based on the court's understanding.
No, based upon the law, councils do not get to determine the length of probation or the conditions of probation. That's not my understanding. That's the law. If people want to get that law changed, they need to talk to the legislature.
It's been my understanding and the practice in this county that the judges allow
Well,
us to do that.
well, I don't want to disparage any judge, but guess what? They're wrong. Because according to the law, according to that document that y'all just signed, the court determines the length of probation. Nobody else determines the length of probation. The court does. So if the state is asking for 8 years probation as the length, I can say, you know what? I've read the facts of this case. I think the person should only be on probation for 4 years or 3 years. That's up to me. Or the state may say, me and the defense counsel believe the person should be on probation for 5 years. I may read it and think, no, that person should be on probation for more than 5 years. I'm allowed to do that. And guess what? That is not going against the plea bargain agreement that you've entered to. So if y'all want to discuss that, you can. But if other judges are saying, oh, the law is that's the plea bargain agreement, then those judges would be wrong. All right. Yes,
I'm not ready to go forward with it then.
then we'll be in jury trial. All right. Macy Malone. All right. So did they give you, and if you want to hand that back. So jury trial is at 1:30. And you can put that in here. All right.
Well,
Macy.
we're announcing not ready on the trial because we were expecting
Oh, you all need to file a motion. I'll hear it and make a ruling on it.
Okay.
All right, Macy. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
yes, Your Honor.
Anything you wish to say on behalf of your client?
Well, you had an ignition interlock on the car?
Okay, you're all gonna have to speak up so that the court reporter can hear.
And have you been abiding by the conditions of bond and
Yes, sir.
not drinking alcohol?
No.
You want the judge to grant you probation and to continue you in with the ignition interlock for 1/2 of the time?
Yes.
All right, do you have any children?
No.
Are you employed?
Yes.
What do you do?
Electrician.
And how long have you been doing that?
About 10 years.
All right, do you own your own business or you
I
work
work for a
under?
company.
I'm sorry?
I work for a company.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated. There's going to be 90 sober meetings in 90 days. With regards to the Bexar County Jail or GPS, 1 or 2 ways. Either you can go to the Bexar County Jail, do your 10 days, or either you will be on GPS for 30 days, partial for work, and it will be only for work. Or either if you don't want to do work, you can be on full house arrest for 20 days. Which do you prefer?
I go to work back to
All right.
GPS.
So because of you, it appears you have on a mask.
Yes, sir.
So because of health issues at the jail, the court will grant you to do 30 days GPS, partial for work. All right, we can go off the record. In this court, communication is key to be successful in probation. If there's an issue, let probation know. If you feel like they're not addressing it, you can always come back to the court. Do you understand?
Sure.
All right, good luck to you.
Thank you.
Judge, thank you so much for granting us this opportunity to come before the court today to hear our motion. As the court may recall, this trial, it was
Yes,
a very intense trial, a very intense.
I
trial.
recall the facts.
I know you recall the
Mine's a
facts.
steel trap. I can tell you the entire case.
I know, and Judge, you and I, we've talked, and not in terms of this case, but I know sometimes you think I talked a little more than maybe is necessary.
No, I do not.
But
It's okay if people want to be Charles Dickens and get paid by the word. I'm fine with
got you. I
that.
got you. So I don't want to do that.
No, you
but-
can. I'm
okay.
serious.
Okay, all right. So as the court recalls, again, this, was a very intense trial. And I'll just basically, I know you know the facts, but just, to, talk about the facts again on behalf of Ms. Castillo. This was, well, Judge, let me say it. They had been together the entire day, not playing with guns, going to the store, doing just different types of things. Her boyfriend was playing with the gun. In fact, a few days earlier, I think he had played with the gun. Had nothing to do with Miss Castillo. On the day of this event, the boyfriend had a gun in his hand. Miss Castillo was attempting to leave. They wanted to go. They were planning on going out. He took the gun and he was playing with the gun that had a beam of light on it, and he was pointing it at her. His cousin comes into the room, says to Miss Castillo, "You're going to let him do you like that?" Takes a clip out of his gun. His cousin's 18 years old, takes a clip out of his gun, hands it to the evidence is either he hands it to Miss Castillo or he throws it on the bed. There was some contradiction as to how that happened. But at some point, Miss Castillo gets the gun, the clip is out of the gun. She thinks the gun was unloaded. Next thing you know, her boyfriend is shot.
All right. So let me just say this. The way I remember
Yes.
the trial is that she was coming out of the shower. She was in a towel. The boyfriend had a gun. His mother had bought him as a Christmas present laser pointers that had the Christmas colors. He pointed his gun at her. It had a green laser on it. His brother tells her, "Hey, are you going to let him do that to you?" And she picks up a gun off the dresser. That's the way I remember the facts. There is nothing about a clip being taken out of the gun. She sees a clip out of the gun. That's the way I remember the trial.
Okay, Judge, and I respectfully want to correct you with that, and I'm pretty sure of that. The argument was that the clip was taken out of the gun. Even in closing argument, I argued that as one of the points as to why it is she did not believe that the gun could fire, because she did not believe that there were actually bullets in the gun because the clip was out of the gun. I probably spent 5 to 10 minutes arguing that point alone. So the clip was out of the gun, which is what we presented as the evidence in the case. And even after the trial, when talking to the jury, a lot of them understood that they believed that the clip was out of the gun. So that wasn't what the case hinged upon, but we did present evidence at the time that the clip was out of the gun. And Your Honor, you are correct that she was coming out of the shower. She did have a towel on because she was planning on leaving. They were planning on going out, but the boyfriend, again, was playing with the gun. So this is a totally different gun. I understand that the state tried to put on evidence, or they put on some evidence, I believe, that the gun had been on the dresser at some point, because and you called him the brother, I think he was a cousin, he was stating that he never brought the gun into the room. But we put on evidence that he did, in fact, bring the gun into the room. Talking to the jury after trial, they believe that too. Now, obviously, the jury found her guilty. We understand that. I did talk with the jury after the trial. The jury placed her on probation, did not sentence her to prison. And the overall thing of it for them was that, obviously, if you have a gun, you shouldn't play with a gun. That's just, and we all understand that. She understands that here today. Nobody's fighting that particular point that you should not play with a gun. But it's important for us to state that the person who was shot and killed, unfortunately, was pointing a gun at her and had been pointing a gun at her. And it wasn't until the cousin introduced his gun and gave it to her, or presented it to her, put it there in front of her, and told her, are you gonna let him do you like that? And she picked up the gun. There's no doubt whatsoever that she intentionally took the gun in her hand. So we're not trying to say that somehow the gun fell into her hand and she had, nothing else to do but to pick it up and shoot her boyfriend. She was not attempting to shoot him. In fact, after he was shot, she immediately rushed over to help him. She did everything she possibly could do to try to save his life. She was hysterical. When the police arrived, the deceased mother tried to say that Ms. Castillo had not in fact shot her son, that some robbers came in the house and had shot the son. And Ms. Castillo said to the police at that point, no, that's not true. I shot him. And so the police did not have to worry about trying to investigate whether or not robbers came in the house and shot the young man, which is the story that the family was presenting to tell the police at that time. She took full responsibility at that particular time for being the one that in fact had shot him. It was not presented as a murder case. It was presented as a manslaughter case because of the reckless nature of this particular incident. After the young man was shot, again, we say that Ms. Castillo was hysterical. If you recall, she was sitting in the yard. She kept calling his name. When she went to the police station, she told the truth. She was forthcoming. She's always been forthcoming. The jury did, in fact, again, find her guilty of the offense. They found her guilty of the offense. But again, I talked with a lot of jurors, which is my normal course after these trials. And many of them believe that that this was a very unfortunate incident, that she had no intention of shooting him, that it was an accident. However, they felt because there was a gun involved and there was some degree of playing with the gun on her part, that she should have anticipated that something like this should happen. But they also felt it necessary that she be placed on probation. After the trial, the court, Your Honor, in talking with her, I remember or recall you intimating that you would be following this case very closely, making sure that she abided by the terms and conditions of her probation, and that if in fact there were any infractions, that could result in her going to prison. We told you at that time that we believed that she was a good young lady, that she would do the right thing, that we did not believe that there was going to be any issue with regard to that. And you intimated that, well, if not, the possibility always is that she might be early term. Of course, the court would not state at that particular point that would be something that would happen, but it gave her something to strive for. It gave her something for which to have hope. And so she has complied with the terms and conditions of her probation. She is up to date on all monies. She's paid all monies. She's done all courses that have been presented for her to do, including a parenting class. She's done all of her community service hours, 200 hours of community service. She is gainfully employed. She's raising her now 2 children. She had a son at that particular time. Her son is a straight A student in school, well-adjusted to school. She has done everything that this court has asked her to do. She is not putting this behind her because she loved the young man that was her friend. And this has been devastating to her. And obviously, it's always devastating to the family. You can never get around that. And you would not try to get around that. But I believe that Ms. Castillo has presented herself well before this court. I don't think you've had any trouble out of her. And she's just tried to comply with everything she's supposed to do. I've kept in touch with her over the years and with her family over the years to see how she's been doing. Having another child, continuing to be employed, keeping up with her probation. I'll talk with her about it. And she says, yes, Mr. Marshall, yes, Mr. Marshall. So I just think that she is a worthy candidate. She is a worthy candidate for early termination on this case. And I would ask that the court would consider terminating her probation.
All right. So the way the court remembers the facts of this case is, as I previously stated, and an expert was called to testify. And the questions that were being asked of the expert were whether or not dropping a gun, because that was part of the defense. The gun was dropped. The gun went off accidentally, and the gun hit at such an angle, a lucky angle, that killed the complainant. And then the expert testified, and I believe it was defense expert, testified that no, this gun would not go off if dropped accidentally. And there may have been some closing argument about, then maybe she didn't know the clip was loaded or not loaded. State?
Well, and after the state, if I may.
Sure.
For argument or about the facts, Judge, because you're the one with the facts.
No. I'll hear your argument.
Yes, Judge, at this point, a jury did, hear all the facts and they heard them as you did, Judge, and they still returned a verdict of guilty. And as we know, they have the option of assessing as low as 2 years if they were going to give probation. The jury chose, after hearing all of the facts and hearing all of the argument, the jury chose to give her 10 years, which seems to be deserved for probation, Your Honor. It does seem like this was a probation-worthy case, but they still chose to assess the maximum amount of probation being 10 years. And we would just ask that the state follow that, and that the judge follow that. Because again, at the end of the day, a young man lost his life. And as we both know from other, expert testimony, just because there's not a clip doesn't mean that the gun's not loaded. And first rule of gun safety, you don't point a gun at somebody unless you intend to fire it.
And if I may, Your Honor, and that's just not the facts of this particular case. I believe the fact in this case, which was undisputed, that she had never personally handled a gun before. Also, when talking about whether the gun fell to the ground or not, I don't believe our argument was that she dropped the gun. Our argument was that because of the type of gun it was a gun that had been known to have a quick trigger. And so questions were elicited as to whether or not, if the gun was dropped, so on and so forth, would it fire? And our expert, which we knew what he was already going to say, basically said with respect to that gun, no. But what we were really getting to was the nature of the quick trigger in this particular case, because there was some issue as to whether or not this gun fired with a quick trigger. And so when having the gun in her hand, is she intending on firing the weapon, shooting her boyfriend, so on and so forth? No to that. But we were, eliciting questions as to whether or not, or answers as to whether or not the gun had a quick trigger. And so our expert witness said he did not believe, in his expert opinion, that particular weapon, although that style of weapon was known to have had a quick trigger, he didn't believe that particular one did, because he was not able to test that gun until, I believe, the day of trial. I think the day he testified was the day that he was able to look at that gun on the stand, actually, is when he was able to do that. Mm-hmm. So with that having been said, again, the jury did find Ms. Castillo guilty. Again, I talked with the jurors after the trial. And in fact, I believe we even argue, or at least let them know that, and I think I even requested at some point that they give her the 10 years of probation, right? And with the idea that if she complied with probation, that she might be early termed. And I talked with some of the jurors about that after the trial, and they understood that if she was in compliance, that, the court had the discretion of early terminating her from probation. So I don't even think that all of the jurors, really thought it necessary that she do all of the 10 years. What they thought was really most important was, one, that she understands the nature of what had occurred in this particular case and how serious it was. Two, that she responds as one, not only with words coming before the court and saying that she's going to do the right thing and be the right kind of person, but that her actions would actually follow. And her actions have. She's done everything the court has asked her to do. She's paid everything. She's done all of her community service hours. She's done all of the classes. She has a very good rapport with her probation officer. I believe the probation officer, the one that, told her to come before the court and ask the court to terminate her early, if my memory serves me correct. So it's just one of those cases where, and I understand, I get it. I understand it's a manslaughter case. Somebody lost their life, and you know what? You just got to do the 10 years. Well,
no, actually, counsel, and I believe afterwards, both you and the state's attorney came before the court after this was all over and asked the court, hey, if we would have came for you on an open plea Do you remember that conversation?
And I believe you said that you would have given her deferred adjudication.
No, what I said was that if you all had come to me on an open plea, that I would have given her deferred because these were two young children playing around with guns. That's what happened. Two young children playing around with guns. And I said their parents were allowing them to play house and play around with guns. And I would have given her deferred adjudication. But where we are now is she hasn't even done 5 years on probation yet. And in the big scheme of things, somebody is dead. I understand that she loved him. I do remember the facts of the case. I remember her being on the sidewalk when the police came and she was telling them that she shot him. And the complainant's mother is saying she doesn't know what she's saying. She's in shock. Robbers came in. I remember that. So I want you to know that I remember all of this. I remember that you were very distraught because the person that you loved died, right? And I know you didn't mean to kill him. That's why it's a manslaughter case. And I know that part of the fault, and I don't like to pass blame around, but parents should not have allowed children to be playing with guns. And I remember listening to the testimony and thinking to myself, I didn't know laser pointers now come in Christmas colors, holiday colors. You know, why are people marketing holiday colors for people and especially children? But my problem with this case in granting you early term is you haven't even done 5 years yet. This is from 2020. You need to at least have done half the time. And I know you can come forward at a third of the time, but at the end of the day, someone's dead. And I'm not trying to make you feel any worse than you already feel. But honestly, they're dead because you picked up a gun. Whether you knew it was loaded or not, you picked it up, you pointed at him, and you fired. So you should at least serve half the term before you come to the court asking for early term. You understand? Yes. All right. So at that point, I will strongly consider your motion for early termination. But now you've just been on since 2020. And I know sometimes people rush through conditions that are given to them. And I appreciate that because I want you to do it. You appear to be on the right track. You're doing what you need to do. But a third of the time and somebody's dead is not enough in this case. You understand?
Yes, ma'am.
So come back when there's 5 years that have elapsed and the court will strongly consider your motion for early termination. Do you understand?
Yes.
All right. Thank you.
Thank you, Your Honor.
You're welcome.
May we be excused?
Yes.
Thank
January 25th, 2025.
Our last date, that was the part of the report attachments where he had allegedly had contacted her through social media after the election.
All right.
So as far as that, Judge, we're pleading no contest. My client has no prior offenses. The
Well,
state
no.
can-
I'm
Well, no,
trying
but
to see if
I'm
there's,
trying to get there. I'm trying to get there. As to our application we are applying for deferred adjudication. And so because of that, I would not want him to make any stipulation. So that's why I asked him to plead no contest. Because if the court should grant him deferred, then
well, here's the thing. I don't have that in the stipulations to prove the 2025 CR 004086. Now, if somebody wants to amend this and attach jail calls, they can attach it, but I don't have enough proof in here for these other dates. The only date that I have in the stipulated evidence is I have a date from January 5th for violation of protective order. But the other dates I don't have in here. Sure. So if y'all want to step back, you can, but in cause number 2025 CR 03533, the court is finding that there's sufficient evidence to find you guilty. The court will defer finding of guilt. It takes about 8 weeks to 12 weeks for a PSI. If you would like to have him come back without a PSI, but just have time to call witnesses, you're more than welcome to do so.
so I've conferred with my client and I've also contacted family members and my client wishes to waive PSI. And just have the court, and that was why we took a little bit of a recess, Judge, before we got on the bench, is just to confirm the criminal history. And so at this time, we're asking the court to waive PSI and we proceed with sentencing today. Your Honor, my client, he's 27 years old. He is not native to Texas. He's from Indianapolis, Indiana. I'm sorry. Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old, is that right? 16? 15. Since they were
All right, does he
15.
want to testify?
No, Judge, let me just finish. I'm so sorry.
All right, so you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay, I'll just
All right.
proceed. I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that obviously he's vehemently opposed because he does have 3 children. And so I did advise him that this would be part of the plea agreement, and if he wants to hire a lawyer and, you know, get some custody issues and orders in place so that they can go around that order, you know, in order for him to be able to see his children, because obviously the state is not asking for a no contact order with the children. It would only be with the mother, the natural mother, which is the victim here. I have spoken to his father. I am not sure if yesterday he was on the Zoom and standby, and I mentioned him that he would at the same time today, and I don't know if he's in the waiting room or not, but notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis. He lost about 110 pounds in those 3 months. So he's had some kind of health limitations. And so a lot of that is going into why we have this agreement. You know, obviously, you know, I've explained to him multiple times, you know, that we could ask for a jury trial from the court. But, you know, given the history with these people, you know, that obviously he wants to accept responsibility, and he's wanting to do that today, Judge. And with respects to just putting it on the record, I do want to state that, you know, we took a little bit of time going over the criminal history. There was a jury trial that happened in December of 2019 in Indianapolis, Indiana. So that's why I'm sorry, I was confused about the city, that there was an actual jury trial and he was adjudicated not guilty with the same victim. There was also, I want the court to take judicial notice of clause number 2025 CI 04103. There was an application for protective order that was made by the victim February 25th, 2025, and it was non-suited in April 17th of 2025. My understanding, and prosecutor wouldn't really talk to me too much with respects to the protective order, Ms. Colon, but she did confirm that it was non-suited due to her leaving the state. So the victim.
Due to what?
The witness leaving the state.
Okay.
So as we stand here today, we have, obviously my client hasn't had any contact with her since then. And then, but she has been in contact with the state, which obviously, you know, we know that is for a fact, but obviously he's very concerned for his children. He wants to know their whereabouts. And he did meet with a recruiter, and I did speak to him on the phone. He would not come in for the PSI. His name is let me see, his name is, Eggerson is his last name, Sergeant Eggerson, and I did call the number, let me see, on Potranco Road, it's 11223 Potranco Road, and, unfortunately, Mr. Ross was in the process of, being recruited, to the Army. And so obviously he understands that accepting responsibility for this charge, and should the court grant him deferred, he will not be able to possess a weapon while he's on deferred. But the hope, I guess, is that once he's completed, the deferred, is that he'll be able to enlist at that time. So our agreement right now is 4 years. Now the court can give him probation, the court can sentence him, or the court can give him deferred, which I believe he's legally entitled to because he has no convictions.
What do you
He's-
mean he's entitled to deferred adjudication
Okay,
legally?
well, I would ask the court to take that into consideration, that he has no legal convictions. Under any other ordinary circumstances, he has no prior offenses,
Okay, but,
convictions. And so
But if you're
because he's a
saying he's-
first-time offender,
all right, but if you're saying he's legally entitled to deferred adjudication on this
I
case?
have no statute.
All right,
If the court, I have no statute, but I'm just saying as a matter of principle, as a matter of, mercy on my client, the court, I should hope, at least, because again, he's also been in contact with, being recruited, that he would be granted deferred adjudication. And, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? You understand it? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that time frame.
all right, so what I can
And
tell
they'll
you,
have to accept the
he's not a
transfer.
good candidate for probation.
He's not?
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bear County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation.
Who
In
said
each
that?
cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors. And cause number ending in cause number 2025 CR 003533. There's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in each cause number? With your attorney, did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because one of these cases carries an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Sorry, may I speak to my bad, please?
Your attorney said that she did not want you to speak. The court has passed sentence.
I didn't know that I couldn't. I thought I had the whole time to testify. I thought she would.
I asked you if
All
you
right,
wanted
so,
a jury trial.
They're going to take you back. If
Can I
there's something
please-
else you all want to discuss, if you want to file a motion, you can file a motion and the court will hear that
Please
motion.
speak on my behalf. Can I please speak on my
I don't know what
behalf?
you-
I just want to testify. I didn't.
Patrick Washington.
Ma'am, I would like to tell you that the day that I left here, they gave me a little piece of paper with the address to go get the UA. I lost the paper and I couldn't find it.
Whose fault is that?
My fault.
Why didn't you call probation?
I did. I called, I couldn't get the Zoom. I couldn't.
No. There's a phone number for you to call probation. I know probation gives you a contact number. So why do you call probation and say, where am I to do the UA?
And I also came over where the county jail is.
Mhm.
And there's a probation place there. And they have no idea where I'm supposed to wait.
Well, let me ask you this. Why do you come back? Why do you call the court?
I came the other day.
No, 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 no.
That's it.
Why didn't you call the court? Because this allegation that's in the motion is from June 9th, 2022. June 9th, 2022. So why didn't you call the court or come to the court and say, I don't know where I'm supposed to go?
I figured that I could, when I went to go, because I couldn't do the Zoom. So I had to go in person that same day.
No,
I
you
figured. I
could have called the court.
Yeah, I could have, I'm sorry.
No,
didn't
why
think of
didn't
that.
you?
I didn't think of that.
All right, so
Yeah.
here,
I figured that on the day that I would go to report, I would do the UA there.
so here's the thing. You didn't do that June 9th. You didn't do it June 10th, June 13th, 14th, 15th, 16th, 17th, 20th, 21, 22, 23, 24, June 27, 28, 29, 30, July 1st. You didn't do it July 2nd, July 3rd, July 5th, July 6th, 9th through 13th, 16th through 20th. And I'm assuming you were taken into custody. So do you have
On
any?
the 7th.
Yes,
You're on, may I ask you?
yes.
Didn't know it was that very.
Just answer my questions.
Yes,
Okay, you pleaded here on the 9th of June.
yes,
When was the next time that you contacted the probation office?
on the 7th
The 7th of what?
of July.
All right, well, did you have no contact between June the 9th and
Yes,
July
I
the
did.
7th? Okay, what was that? That's what I said. What was
1
your next
week.
contact after the 9th of June?
A week after that,
A week after that?
yes,
And where was that?
right there at the probation office.
And what did they tell you then?
That they didn't know where I had to do the UA. That's
So-
what they told me.
So what did they tell you to do?
Wait till I go to probation and report.
What do you mean, for the reporting for the next
The
month?
7th, on the
The
7th,
7th of July?
yes.
So
And
you
then-
reported on the 7th of July?
Yes, for they told me to go over there. I took the bus to the place. They told me to report and I was there waiting for my UA and to report.
And then what they do, they arrested
They
you?
arrested me.
And so you've been in jail since the 7th of July
Yes,
because of this failure to report in the first place for the UA.
yes, which was given to me in a little very small paper. I could not find it.
Okay, so now between the time that you went to the probation office shortly after the 9th and up to the 7th, so your understanding, you weren't supposed to report any of those days for the UA, but you'd get the UA when you reported on the 7th of July.
Yes.
Okay, all right.
Yes,
All right,
Exceptional.
so thank you.
No,
It's a misunderstanding.
All right, well, let me clear up all misunderstandings. This is my communication with you.
Okay,
You're either getting revoked, which I think you should be revoked, or either you're going to inpatient treatment or you're going to felony drug court. Those are your choices. This is what I know about people who are addicted to drugs and who are in the throes of their addiction. They can tell you the moon is made of green cheese, and they give you such a great story that you start, wait a minute, is the moon really made of green cheese? So this whole thing about you being given a little piece of paper, not knowing where to go, that's a nice story. So you have a choice. I can sentence you on the state jail felony. I'll sentence you to 2 years to do. On the felony case, punishment is to be assessed at 8 years. I'll give you 4, run them concurrent, or either you can go to felony drug court or some type of inpatient treatment. Those are your 2 choices. So which would you prefer?
felony drug court. I have to take care of my son.
Well, I don't think you can take care of how old is your son?
37.
Yes, he's gonna have to find somebody else to take care of him. Because let me just tell you right now, if you're trying to be a home health care provider for him,
No.
I don't allow that.
no,
Are you
he
being
has-
paid for that?
No, he has his own provider. I don't provide for him. I'm glad that someone's there taking care of him. He lives there.
All right. So in each of the motions,
My
the court
house.
is going to deny the motion, alter and amend conditions.
Your Honor, may I have a second?
Yes.
I believe that the state has recommended the felony drug court because of her past history. She had convictions in the 90s for a drug case. But I don't think she should talk to that anymore. Is that right?
I don't have a drug problem.
Okay,
Here's the
but-
thing, the fact that she wouldn't go to a UA tells me there are issues with her. So here's your choices. You can go to prison, or you can go to felony drug court, or either go to an inpatient treatment.
I will go to felony, drug court. Yes, ma'am.
And if you're not accepted to felony drug court, or you're not accepted to inpatient treatment at SADF or ISF, what we're gonna do, probation? All right. We're gonna alternate amend conditions in each case to include a referral to felony drug court. I'm gonna want the TAP evaluation. If felony drug court doesn't accept her, then she'll go to SADF. If she goes over there and pretends that she doesn't have a drug problem, then we're gonna do ISF cognitive. And you're to remain in custody until that is done. And if there's a TAP evaluation that needs to be done, then also do the TAP. Is there anything else?
Nothing.
How long?
That's all we have. Right?
I'll do anything to stay off drugs, anything. I need to be with my son. I care about him.
All right, well, you're doing a poor job of showing you care for your son by not doing what you're supposed to do while you're on probation. So you're gonna have to do better. And I want it stressed that she is not to be a home health care provider or work with minors at all. I don't know what's happening in that household. I don't know if he's receiving a government check and you're getting part of that government check, but if that's the case, that's gonna stop. Do you understand?
Yes, I understand. That's my house. I paid for I worked, I injured myself and that's why I'm not working, but I have always worked. I paid for my house. I didn't get no assistance of nothing. I worked always. And I'll prove you right that I'm not in drugs.
All right. Good luck to you.
Thank you.
Thank you.
You some questions, and the questions, oh, thank you. The questions that I'm going to ask you are related to your representation. It's not about the facts of the case. If it were about the facts of the case, then the state would need to be here. This is just a determination of whether or not I find that you should be allowed to represent yourself, okay?
Okay, it's like qualique.
Hmm?
This is a qualique.
A what?
Qualique to see if I'm able to represent myself. If I
Yes.
understand. Okay.
All right. So how far did you go in school?
I mean, currently in school right now. Should be graduating next year, but now that I'm now getting behind with finals because of.
All right. So here's the thing. The best thing about being a witness and what attorneys always tell witnesses is just answer the question that's asked of you.
Okay.
So how far are you in
I'm
school?
currently in college now.
All right. What year?
I'm considered a sophomore/junior.
All right. And what are you studying?
Law.
All right. And how many years have you studied the law?
I'll say about 5 years.
All right.
But it was in the civil litigation and family law. And
So have you ever studied criminal law?
I never had a desire to learn about it until now that I'm going through this.
All right. So remember what I said. Just answer the questions. Have you ever studied criminal law?
I've never studied criminal law, but based on my study, it's like all civil in nature.
All right. So here's my other question for you. Do you understand you have a right, because this is a criminal matter, you have a right to have an attorney appointed to you if you cannot afford to hire an attorney? Do you understand?
Yes, ma'am.
All right. So do you want to have one? Can you afford an attorney?
Well, at
That's
the moment,
yes or no?
At the moment, no, because of
All right. Then the
I
next
think-
question, here's the thing, just listen to the questions. All right. Are you able to afford to hire an attorney?
no.
All right. Would you like an attorney appointed to you? That's either yes or no.
But I'd be able to speak to counsel, like someone from my counsel, to be able to make a decision. I don't want to just rush and say yes and no when I don't.
No, I mean, here's the thing. You don't get a chance to choose who your attorney is.
Yeah.
My question for you is, and I just want you to answer my
Yes, ma'am.
questions. Would you like to have an attorney appointed to represent you? That's either yes or no.
Your Honor, I'm sorry, I'm like, I just feel like I'm being pressured and rushed and I don't.
No, you're
wanna
not being
make
rushed.
that
This case has
decision,
been
right?
going on since January 2025. Let me explain something to you. When this case comes to trial, it is going to trial.
Yes, ma'am.
There's not going to be at the last minute, I decided I don't want to do this. Let me get an attorney and get another reset. That's not going to happen. So my question to you is, do you want an attorney appointed to you? That's either yes or no. If your answer is no, whatever ends up happening, you end up representing yourself, then you're going to represent yourself. I'm not going to give any resets because in the middle of trial, you decide you're over your head
Mhm.
and you need an attorney. That's not going to happen.
Your Honor, with all due respect, my attorney, I had.
Here's the thing, don't start with,
Yes, ma'am.
with all due respect. And let me just tell you why. No, no, no.
Honorable and.
This is what I want to tell you. When people say with all due respect,
Mhm.
they're really getting upset. And usually what comes after with all due respect is not with respect. It's like when people say, let me be honest with you. Usually what's coming is not honesty.
I'm so sorry. I wasn't trying to go that route.
No problem.
I was just wanted to say with all respect, Your Honor, the reason why I withdrew from my attorney, there was an issue with discovery since day one when I
Okay,
hired
here's
him.
the thing.
Mhm.
I don't get into things about you and attorneys and what happened with your previous attorney
Mhm.
unless a previous attorney is here
I
to
understand.
give their side of things.
Yes. So, like again, Your Honor, so I'm not afforded my due process rights. I don't know, it's like, to me, it's like you're making a judicial decision and I don't.
It's not. It's either you want an attorney to represent you and afford one.
I'm asking you nicely, Your Honor, if I could have some time to make that decision. Because I don't want to make the right decision if I'm going to defend myself. I'm already having lack of discovery.
My answer to you is no.
Yes.
If you want an attorney appointed to represent you, that attorney is going to be appointed today. You're going to meet them today. If you don't want an attorney appointed to you, then one will not be appointed to you. And your next setting is going to be a jury trial. And when you come in, it's going to trial. That's where we are. And I'm going to tell you again,
Mhm.
previously, when you were saying you were filing your bill of particulars,
Yes, ma'am.
I am not going to be an attorney for you. I'm not going to show you how things legally should be done or the legal process, because the last time you were here, I was helping you with your motion to say, is this what you mean? I'm not going to do that anymore. I'm just going to look at your motion. And if your motion is not in the proper order, if your motion is not asking for appropriate things, it's just going to be denied.
Mhm.
So it's not going to be my job to walk you through questioning of witnesses. I'm assuming if this goes to trial, the state is going to call witnesses.
Okay.
Not going to be my job to help you cross-examine them. It's not going to be my job to teach you the rules of evidence or criminal procedure. That's going to be all on you. And if you're not following those rules and the state objects, and it is an appropriate objection, then it's going to be sustained.
Yeah, I'm
So-
not asking for any legal advice or.
You have been, though, because the motions that you've been filing have not been appropriate motions. Your bill of particulars, when I read it, it's really not a bill of particulars. What it is a request for this is going to be going to trial.
Like, I'm trying to be respectful as possible, Your Honor, but
No.
you're applying pressure on me to make a decision, and everything is moving fastly. Like, I don't consent to go to jury when my due process has been violated. I'm praying that you can hear me out, but it seems like you're pushing me into making a decision without.
No, so let me just explain something to you. Your attorney was here at the last hearing. Your attorney said that he's already shown you all discovery and you received that. And here's the thing, you're saying that's not true,
I have substantiated evidence, Your Honor.
but listen to me, put on your listening ears.
Yes, ma'am.
This is what I'm telling you. Your attorney, the attorney that you hired,
I didn't hire him.
your attorney,
I didn't hire him.
your attorney said that they gave you all the discovery. Sometimes people receive discovery and they don't like what they're seeing. That's fine. That attorney is a good attorney.
Mhm.
That attorney has not had any violations, no ethical concerns by this court or by the state bar. That attorney said that you had already received all of the discovery. That attorney even has a portal on his website where his clients can go in and look at the discovery that he's received. He said that you've already received that. So you're coming to me saying that you haven't received discovery? Your attorney says you have.
Yeah.
So, nope, let me stop you there. So what I am telling you is this is going to trial and you're standing before me saying that you have not received discovery when your defense attorney says, I have given you the discovery and I have no reason to disbelieve your attorney. Your attorney has never given this court any reason to disbelieve him when he says that you have received discovery.
Mhm.
Their question, and this is the last time I'm going to ask it, and you can answer it. If you don't want to answer it, that's fine. This case has been on the docket since January. What I am telling you right now is you will answer yes or no. If you don't want to answer it, you don't have to answer it. Do you want an attorney appointed to you? Yes or no?
I'm under pressure. I don't understand.
All right, that'll be no.
I'm being
Ms.
respectful,
Ferguson, place this on the jury trial with Judge Angelini on June 16th.
so I'm not able to talk, Your Honor.
Sure, you can talk. Go ahead.
So I have placed on the record, Your Honor, substantiating evidence of the proof that I have not been able to receive discovery. On May the 3rd, May the 3rd, I have received an email of some more discovery that my attorney sent me after I filed a motion to withdraw from him. The only reason why I filed this motion to withdraw from him is because of the lack of discovery since day one. You know, Your Honor, every time we came here, it was, oh, Your Honor, the file's too big. Oh, Your Honor, I don't have, I haven't got it from Jason. Oh, Your Honor, he has to come in and buy a hard drive. Like, he made me as his client get a hard drive to go get it, and he still didn't give it to me in a hard drive. Your Honor, I have substantiated evidence to prove my facts, and I have submitted it. I have filed it in the clerk with the clerk. So if he's willing to say what he said to you in court, that he sent me discovery, I would love, Your Honor, if he could do a sworn affidavit statement stating what he said, so it could be put into.
He's an
evidence.
officer of the court. So he doesn't have to do a sworn
Yes,
affidavit.
I understand, but I put the burden of proof. I showed the burden of proof, Your Honor, of my facts. I'm showing you that I did not receive discovery until Saturday, 2 days before trial, 2 days before court date hearing. If you can look in the system, you'll see an affidavit statement signed by a notary that I signed under perjury, under sworn, I swore in and I under perjury. I'm not trying to go to jail for lying. I'm telling the truth, Your Honor. He did not give me discovery until it was a Saturday, that Saturday before court. And it's big, it's a big file. And how could you miss that? Yes, he did send some before, but he's piecemealed, Your Honor, 1 month, 2 months out, 2 weeks after that, in 1 month after that. It's like he's been piecemealing this stuff to me. And then he says that, oh, the file's too big. And this would make me make the decision to withdraw from counsel because he's not the best fit for me. Maybe he's a good attorney, but he's not probably the good fit for me. And this would make me want to represent myself because I wanted an attorney. But after I went through 6 months with dealing with him, and I was very patient, very patient. I didn't say a word. I didn't get upset with him. He wanted me to take a plea deal before I even got discovery. And that's what really made me not upset, but made me a little concerned because I'm like, you're representing me, but you want me to take a plea deal without me having discovery? Like, where's my due process rights? You know, that's a violation of my due process rights. I need to be able to defend myself. I cannot defend myself properly if I don't have all the evidence in front of me. That's all I've been trying to say.
Your acknowledgement of discovery was signed, that discovery was received on April 14th. Ms. Ferguson, could you have somebody from the state come down, please? And if you'll give him a reset form for June 16th.
So, Your Honor, you're denying the fact that we have to go into jury without my due process for the record. I just want to know, Your Honor,
Oh.
for the record.
For the record,